The Socio-Economic Rights and Accountability Project, SERAP, has initiated legal action against the Senate President Godswill Akpabio and 9 other former governors who served as senators in the Senate. SERAP's lawsuit filed at the Federal High Court in the nation's capital, Abuja demands that Senator Akpabio and the other senators cease collecting both salaries and pensions as former governors and return any pensions received to their respective state treasuries. The organization also seeks clarity on whether these individuals have been collecting both salaries and pensions, as well as disclose the amounts received. SERAP argued that the Nigerian Constitution's 7th schedule mandates former governors to halt the collection of both salaries and pensions. Failure to grant these relief would allow the former governors to maintain life pension benefits while simultaneously receiving salaries as serving public officers, creating a situation the organization deems a travesty and private self-interest. Now, joining me this evening on the conversation is Kolawole Oluwadare, the Deputy Director at SERAP. A warm welcome to you, Kola, and thanks for joining us on the program.
Good evening, Gbenga.
Now, Kola, could you explain in more detail the lawsuit that your organization, SERAP, has filed against the Senate President, Senator Godswill Akpabio, and 9 former governors serving in the Senate, and what prompted SERAP to take legal action against these individuals?
Thank you very much, Gbenga. So the suit is predicated on 2 issues, really, to call it a course of action that we have in the suit, which is the public interest lawsuit, which unfortunately shouldn't have been one of those things that should end up in court, but for the lack of adherence to the rule of law by public officers in Nigeria. In this instance, these members of the National Assembly who are former governors. So the 2 issues that I've mentioned, one is a request for information and the other is a request for action. The request for information is predicated on the Freedom of Information Act and the freedom of expression provisions in Section 39 of the Constitution, while the second is predicated on the request for action, predicated on constitutional provisions, particularly the Code of Conduct of Public Officers. As to the first issue, we are asking these members of the National Assembly who used to be governors to disclose to Nigerians if they are earning pension from their former state of governors and how much they've earned. And on the other hand, we're asking for them to return, if perhaps the answer to this question is in the affirmative, to return such funds that have been paid. And there are 2 aspects to this issue too, Gbenga. There is the issue of payment of pension to former governors, which of course we consider as unlawful and immoral in every aspect. And then there is the issue of what we would call a double emolument, which is the payment of the receipt of pension as former governors and deputy governors by these individuals who are also receiving pay as members of the National Assembly. And this aspect of double emolument is clearly an infraction of constitutional provisions, particularly the Code of Conduct of Public Officers, which is in the 5th schedule of the Constitution, particularly paragraph 2A, is very clear. And that means that the Constitution has envisaged that perhaps this kind of issues might happen and has specifically and particularly outlawed this kind of practice. And don't forget, infraction of the Code of Conduct is the basis for impeachment. It is a basis for trial before the Code of Conduct Tribunal. And paragraph 2 plays clearly that a public officer shall not draw payments of emoluments or salaries from a public office at the same time where he or she is also drawing pay from another public office. And in this instance, this applies to these 10 senators, including the Senate President, who earning a pension from their former states of governors, which of course is inherently unlawful in itself, and also earning a pay as senators in the National Assembly. And this is against the background of extreme poverty in their states. In some of these states, backlog of pensions are being owed, and worker salary are not paid, and there are poor people. And so it's really not justifiable either in law, morality, or looking at it in plain economic terms.
Kola, some might justify it on the basis of, you raised the issue of double emolument. These were governors and they served their time as governors. Some one-time governors, some served for 8 years, 2 terms. Now they have a different brief. They are senators of the Federal Republic. It's a different kettle of fish. They're serving in a different capacity. Don't you think they should be entitled to what they earn, because it's their time, it's their experience, it's their expertise they're taking to the National Assembly, and they do have to be physically present. It does involve a lot of work. So asking them to suspend payment based on their past might seem unfair.
It's
Or you
not
don't think
unfair,
so?
Gbenga. That is a provision of the Constitution. And it's of such importance that it is not stated in any other law. It is in the Constitution, it's a constitutional matter. And it's in the Code of Conduct of Public Officers, which is binding on all public officers in Nigeria, including the president. And don't forget, like I've mentioned earlier, infraction of the Code of Conduct in the Constitution is a basis for impeachment. It is a basis for trials before the Code of Conduct Tribunal, which naturally frowns at this kind of practice. It is on the same pedestal as false declaration of assets and all the provisions in the Code of Conduct that are considered acts that are not worthy of a public officer. So it is
yes.
not an issue that they are serving. It is unlawful.
Okay. Now, Kola, your organization has decided to file a lawsuit against the Senate President and these individuals. Are you filing the lawsuit based on information you have? Because you also said there's a freedom of information request. What concrete evidence does SERAP possess to substantiate the allegations of simultaneous salary and pension collection by these individuals?
Thank you, Gbenga. I mentioned earlier that a lawsuit is precedented on two legs, the course of action. One is a request, and the other is one is a request for information, and the other is a request for action. We had written to all these to the 10 respondents, including the Senate President, by way of a freedom of information request, where we've made requests as to how much they've earned, or perhaps they're earning from these from their states as former governors, and how much they've earned so far, and also made a request for them to return these funds. It is we did not get a response to that request in line with the 30-day period provided by the Freedom of Information Act, which is why we're in court to compel them to disclose that information to the Nigerian public. And then we've gone a step ahead to say if they are earning these pensions from their former states, then they should take those steps to refund the amounts that have been collected, because it is an infraction of the Code of Conduct for Public Officers. And this is also against the background of the judgment of court that have been given in 2019 by Honorable Justice Ogutoyibo of the Federal Court, Lagos, in November 2019, which has challenged the legality of state pension laws, which is yet to be obeyed. So from all ways, from every way you look at this is not only immoral, it is unlawful, and it cannot be justified on any economic grounds, particularly when you consider that these are public officers who have served 4 to 8 years in their respective states, who are earning a lot of money. You need to understand context for these amounts of money that they're earning. And just to give a bit of context to it, 200 million naira annually for the Akwa Ibom life pension law, for instance, 2 official vehicles and whatnot. It's just too much. It's not sustainable.
And then still collecting benefits and salaries as a serving senator of the Federal Republic. Now, Kola, I know you touched on the legal aspect of this, but let's get into more details. Could you elaborate on the legal intricacies involved in this case, particularly the constitutional provisions and statutes that support SERAP's argument? I know you just touched on the precedent of the judgment given by Honorable Justice Remi Oguntoyibo in the Lagos High Court. What else what other evidence or bodies of evidence do you have as an organization to pursue this case?
Gbenga, I can assure you this is not a case of there is no evidence. You will explain that. There are lots of evidence in this instance. And I'll look at it from the two-pronged issues that we have before the court, which is the payment of pension to former governors on the one hand, and the issue of double emolument, that is payment of emolument by senators who used to be former governors. So starting with the payment of pension to governors, Section 124, Section 5 of the Constitution provides for the ability of state House of Assemblies to make laws for pensions for former governors and their deputies. And it's very instructive to know that the provisions of this section of the Constitution, that is Section 124, Section 5, is permissive. It allows state of assembly to make those laws. And it uses the word may, which of course, naturally, is permissive from every kind of interpretation you want to employ to interpret that section. That is different from Section 84, Sub 5 of the Constitution, which pertains to the president and vice president, that is payment of pension and guarantees to president. It uses the word shall. So in this instance, Section 124, Subsection 5 allows states or assemblies to make laws for former governors for pensions, but it is permissive. And when you look at the way laws are interpreted and read, naturally, laws are read holistically. It means that this aspect of the Constitution will not be read alone. You must read it with various aspects of the Constitution, which includes the Code of Conduct for Public Officers and the Oath of Office, which is very important for any public officer. So these permissive sections, why would state or assemblies use these permissive sections to make laws that will benefit just two individuals out of the millions that reside in the state that are poor, and have left other aspects of the Constitution that are permissive? For instance, the provisions of Chapter 2 of the Constitution that provides for socio-economic rights, that afford free education for all Nigerians, free basic health care, good roads, and all that. They opted not to do that, which would have been more beneficial to most people, but opted to make laws that will benefit people out of the millions of people in their states. And that is on one hand. On the other hand is the issue of the double emolument for those who used to be governors but who are now members of the National Assembly. The Code of Conduct for Public Officers in the 5th schedule of the Constitution is very explicit. That is paragraph 2A. It forbids that kind of practice. And so it shows you that the drafters of the Constitution has envisaged that these kind of issues might come up and has made a law and put it in the Constitution that forbids that kind of practice. It stops any public officer from earning from two offices at the same time. And the reasons are obvious, really. It is not only unconscionable, it is just not sustainable in economic terms, because these are public officers who, as it were, have been fed, clothed, and living a very ostentatious lifestyle, if you can call it that, at the expense of taxpayers. Then why would we have this issue of double emolument? And Gbenga, it's very important again to understand the context. These monies are just too much. Perhaps you will give me a chance.
Sorry to interrupt you. Still staying on this issue, Kola, I remember you also spoke on the morality of earning this sort of money. So I remember when I was on radio, I had a debate once on whether footballers should be earning the type of money they earn, that you have firemen, you have teachers, and that it's unfair. But people argue that, you know, the business creates that sort of revenue that can allow for them to pay that amount of money. Now, how has the practice of collecting both salaries and pensions by these individuals that SERAP has decided to file a lawsuit against impacted the fiscal health and resources of the state they previously governed?
Perhaps I'd wanted to go into details of some of the payments, just to have some kind of context. And reading from the Gombe state law, for instance, there is a 300 million pension for ex-governors and their deputies, and a tax paid, all expenses paid, through for them, along their wives, annually. And that of Akwa Ibom State, from which the Senate President comes from, clearly provides for 200 million naira for a former governor, 2 official vehicles with a chauffeur, a furniture allowance of 300% of basic salary, replaceable every 4 years, and 8, the cook, a lifetime guard worth 5 million naira. The list goes on and on, almost like a bad dream. But so when you look at the impact of this on these states that are poor, that have a majority of poor people, that all backlog of pensions, these states do owe pensions to workers who have served the state for up to 25, 30 years. And then there are unpaid salaries. These are states that are barely struggling. Some of them do owe. They cannot pay the minimum wage. How can you justify these payments?
I mean, it sounds, looking at the present economic realities in Nigeria, and for the last, since the advent of democracy, and looking at the per capita income and the level of unemployment in the country, these things you just reeled out sound so ridiculous that it can happen in this country. So how did it become law in the first place? How did they get away with passing such an obnoxious pension package? Can you shed light on any, since it's become law, since they're earning it, that means there might be some loopholes. Now, could you shed light on any loopholes or ambiguities in existing laws or regulations that have allowed such immoral, to use your word, practices to persist?
I called it immoral, you call it obnoxious. I'm sure the common man on the streets can find a much more bigger word to define it. And any way you look at it, it's just not certain. And it impacts negatively on the majority of poor Nigerians. 130 million poor Nigerians at the last count by the Nigerian Bureau of Statistics. It's not just justifiable. I've spoken to the legal basis of those laws. Section 124 or subsection 5 of the Constitution allows civil assemblies to make these laws. And it uses a permissible phrase, may. And that is the constitutional provision that these states have exploited negatively in the interest of against the interest of their people to make these laws. And that is why people should be able to hold those in public offices to account. In this instance, those members of the House of Assemblies in these respective states to repeal those laws. Just because the Constitution allows you to make a law does not mean you must make a law. Again, the word used in the Constitution is may, not shall. And there are other provisions of the Constitution that are permissive as well. For instance, Chapter 2 of the Constitution, that the Nigerian government has not deemed it fit to do. Then why do this? And the reason for doing this is just because it benefits those who are in public offices, and then they can continue to earn these monies at the expense of the poor people in their states who are really suffering the brunt of this waste of public resources. Really, the only way I can look at it is just another act of malfeasance in governance that a lot of people are going to get away with. Sadly so.
Now, Kola, what broader implications does your organization, SERAP, foresee for Nigerian politics and governance if this lawsuit succeeds? And also the technicality of it, because you just spoke of the state houses of assemblies having to repeal the laws, these pension laws. If that is the case, or if that's the way the law works, then what's the purpose of the lawsuit?
The lawsuit is, first and foremost, it would empower Nigerians by having this information at their fingertips. These are information that should ordinarily be in the public domain. These are public funds. These are information Nigerians deserve to know. Those in this state deserve to know who is earning what and how long he or she has been earning. So that would empower the people with this information. It would be a victory for access to information. Secondly, it would hold those in public offices accountable to their people, to how they spend taxpayers' funds. And ultimately, for those who have earned these funds and who will have to return them when the court rules in our favor, it will be a victory for democracy, a victory for the people, that justice is being done. Really, returning these funds will be in the same vein as Abacha looks, really, because this is just criminal. These funds cannot be said to be legitimate. Just because he has a clothing of legality around because the law of the National Assembly doesn't make it just. Which is why we have the instruments of the courts, who periodically set aside laws because they conflict with constitutional provisions. And in this instance, these laws conflict with provisions of the Constitution, the Code of Conduct of Public Officers, the oath of office taken by these public officers, and we want the court to do away with these laws insofar as they are inconsistent with constitutional provisions, and that is the law. And I see no reason why the courts will not side with Nigerian people in this instance.
Now, Kola, are there any specific historical or recent cases that serve as precedents or reference for SERAP's legal actions? And can you also elaborate on the economic consequences for Nigeria as a whole if this practice continues unchecked?
I mentioned Honorable Justice Obodoyibo's judgment in 2009. This was a case brought by SERAP. Then we had tried to compel the Attorney General of the Federation, who was the chief officer of the Federation at that time, or still is by nature of that office, to take steps. And the court agreed with SERAP and ordered the court to challenge the legality of the state pension laws and to seek for a refund of funds that have been might be unlawfully paid out. That is still the judgment of court. Still tomorrow, it has not been set aside. It has not been appealed. So we do not only have a precedent, we have a precedent that was brought by SERAP. Court agreed with us at that time in November 2019, that is the Federal High Court, Lagos. So there is precedent in terms of case law, and there is precedent in terms of the law, the letters and the spirit of the Constitution itself. No other law is more supreme than the Constitution. And these are constitutional provisions that actually forbid this practice. As to the economic consequences of this, it is profligacy at its highest. We cannot sustain this payment. No wonder Nigeria is so broke. We are needed. Not even needed. We are needed in debt. And these are states that owe salary, they owe pensions, they are poor states. We have a lot of poor people in these states. And these are states that cannot even afford to pay the basic minimum wage. yet wasting these millions of, and the amount of billions annually when you compute all of them together on just two individuals, the governor and the deputy. And when you compute the number, and the list continues to grow, Gbenga, from 1999 till date, you're having much more people within the band of those who would earn this pay. It is just not sustainable in economic terms.
Okay.
It means funds that we use for other things are being wasted on just a few people.
Thank you so much, as always, for your insights and contribution. We'll continue to monitor this case and reach out to you for your expertise as time proceeds. Thank you, Kolawole Oluwadare, Deputy Director at SERAP. Thanks for your time.
Thank you, Gbenga.